Morning, gentlemen. This is the regular scheduled meeting of the Auctioneer Commission. Unless you'd like to open up with some comments, we can jump right in.
I do have a change to the agenda. After the 2019 meeting dates, we're going to add a task force update.
Perfect, that'll work. All right, well, let me just jump right in with the roll call then. Mr. Lewis?
Here.
Mr. Morris?
Here.
Mr. Thorpe?
Here.
Mr. Collier?
Here.
Mr. Lowe?
Here.
We have quorum, Chair. For the notice of meeting, notice of the November 19th, 2018 meeting of the Auctioneer Commission was posted to the website on November 9th, 2018. And looks like we're right there for the agenda then. Subject those changes, unless there's any other changes, we can entertain a motion to approve.
I'll bring up, we typically in August elect new chairman. I don't know if we need to do that again this year or not, but just I bring it up for discussion.
Per usual, you're right on point, and I had that on my notes, so we were going to discuss that later on in the meeting, but we can do that either in new business.
Does it need to be added to the agenda or not?
I was going to give you an opportunity to discuss that among yourself, or we could even wait till the next meeting.
Wait then.
So
let's not add it at this point.
Okay. All right, excellent. That sounds good. We're all on the same track then. All right. Well, in that regard, is there any motion?
I move we accept it with the amendment.
Second. Mr. Morris moves. We accept the agenda with a change. Second by Mr. Collier. All in favor say aye.
Aye.
Any opposed, no. Minutes.
Mr. Chairman, I've read and reviewed the minutes from the last meeting. I move that we adopt them as written.
Second.
Motion's been made by Mr. Morris, second by Mr. Collier. Any discussion on the minutes? All in favor say aye. Aye. Any opposed, no. Minutes approved. Application review.
Yes, it's we don't have an application per se, but we do have one that was brought before us. And if you can, I'm gonna give you the scenario. Basically, what it boils down to is this person will need to make a vote to determine whether or not we want to approve her to test. Miss Graham, file F114. She was first licensed as an apprentice in 1999. Was approved for an upgrade to auctioneer in 2001. License expired in 2005. PSI requires logs from their time as a apprentice and proof of their 30-hour qualifying ed. She has the 30-hour certificate from Nashville Auction School, which I have a copy of that here if anyone wants to see that. But she doesn't have proof of her logs. We don't retain that information from that period, but it's safe to assume that she had her logs if she got her upgrade. So it's really a matter. It's an administrative matter for PSI since we don't have the physical logs. We can't go back to her supervising auctioneer because he's now deceased, and so she's just asking the board for permission to test.
Motion that we approve that.
Motion's been made to approve. Is there a second?
Second.
Second by Mr. Lowe. Any discussion? All in favor say aye.
Aye.
Any opposed, no. Passes. Director's report.
I did have one more item for application review, if you wouldn't mind indulging me for one more moment. There was one issue, and it's an administrative issue that I just need some guidance from the board in regards. It's in regards to a workaround that we've done in the past, but once it came to my attention that we were doing that workaround, then I wanted to make sure we had authorization from the board, and from what I could tell, I didn't see anything formally in that regard. So, but let me give you the scenario right quick, what the issue is, and then what the workaround was, and then of course we'll be free to discuss. The issue is between two issues. Our statute 6219.111 basically states what the requirements are for licensure. That's an apprentice auctioneer under the supervision of a licensed full-time auctioneer for a period of 2 years, and they're also subject to 30 more hours of rigorous classroom material. Of course, you're aware of that. Okay, fine. Rule 160 basically requires 6 more hours of continuing education at the time of renewal. We're fine with that. The problem is making the bridge from that statute to that rule, and so, and this is why, they have to have 2 full years according to statute, under a supervising auctioneer. So, if we were to renew them before that 2 years, before they were subject to a renewal, then at that point, that person is 2 years minus a day. That's not full 2 years. They haven't met that statute. So we could wait till after the 2 years, but now they're in a renewal period. And so now they're subject to the fee and to the extra 6 hours. Although the statute says 2 years and 30 hours, without doing a workaround, we're forcing them to do 36 hours and paying the additional fee, if they lapse into a renewal period. So not every applicant's going to be affected, because we have some that, they're not done in 2 years. They haven't got all their hours, and so we're not talking about those folks. What we're talking about is those that are ready, did all their work, and are just waiting for their 2 years. But if we wait to the 2 years, now they're in a renewal period, and we're expecting more money and additional CE from them. So we're just asking that we can continue the workaround. That's it.
I don't see any problem with that. I mean, a lot of people jump on it, some people don't. And in fact, with the task force, we're looking at maybe even reducing that period even more. So anything you can do to expedite that, and it works for you guys, but I think we're fine with that, and I would make a motion that we allow you to continue to do what you're doing.
Is there a second to that?
Second.
Motion's been made and seconded. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. Anything else? Director report, budget.
All right, great. Let's take a quick little gander at the director's report. As you know, that when we get to the budget, when we come out of a fiscal year, I try to give everyone a snapshot of our overall health, but also drill down and hit the trend as well. We don't do that every single time, but when we have the numbers, we do. So the fiscal year numbers came in for 2017 and 2018, or excuse me, fiscal year 2018. So I want to make sure you have that. So we'll lead with that first. Basically, we added about, roughly, if you go to the very bottom, that's the bottom line. You're looking at about right at $50,000, 40 something added to the overall reserve. Nothing really looked out of the ordinary from what I could see, based on the expenditures that I saw. But if you want to move to the next one, we have the education recovery fund as well. And if you see there, if I can get there myself, looks like we've added about under $20,000 to the reserve there as well. So we'll have to continue to watch that, because we don't want to. We're not in the habit of just adding money to our reserves. So we may have to get creative at some point in the near future if that continues. Action.
Glenn, point us to exactly what numbers you're looking at, because I'm not sure I'm following you.
Go to the first page.
Regulatory boards expenditures?
Yes, sir. And that's the general budget.
The grand total, 49 or whatever.
The very, very bottom?
Yeah,
that's
it says, all right, the reserve balance after core expenses, 461,844.
Yes, sir. That middle row, what you were looking at was the expenditures. And then, of course, you've got the revenue coming in as well right below that. And then once that has been reconciled, that leaves us with a balance of 461.
And by law, we have to have, what, 250,000?
I think that's the minimum.
Right. So we're $200,000 over that.
And of course, the minimum. There's a safe range. I've seen some of the other programs. There's not too much concern over auctioneers in particular. But again, when that's why we watch the trends. If we continue that way.
So what's the difference between that number and the number on the next page says prior fiscal year reserve?
Yeah.
What are those two different numbers? Look at this page right here. It's got.
Oh, I got you.
Fiscal 14, 15, 16, 16, 16, 17, 17, 18.
Gotcha. Okay.
And then the next page is prior fiscal year reserve. It goes from 223 up to now 277, 380.
Are you looking at the?
I'm looking at page 2, whatever that document
Okay, gotcha.
is.
Yeah, that's our education recovery fund.
All right. So what's the 461 reserve balance?
Oh, that's the operating budget. I'm sorry, the general budget. The first page is the general budget. And
Reserve balance. That's for the general fund for you guys.
That's correct.
And then the second page is the 277. That's the actual recovery fund reserve balance?
Correct. I'm sorry,
Okay.
I didn't understand.
All right. I'm just trying to follow. And we haven't had any expenses out of that recovery fund this year, have we not?
We did this year.
What did we have?
We had the seminars.
Okay. And that's all?
And we did have to reconcile that. If you notice, the year before, that total was really low because that money came out of the general operating budget. And so,
it was run 60, 63, then went down to 4, now back up to 46.
You got it, right. Once I noticed that, I noticed that we are.
To get that benefit, and they never did catch it, or what?
They were just tracking it from the general budget for, I think, a couple years in a row. And so when I noticed that was happening, I brought it to their attention, and of course we reconciled that since. So as you see that balance now in the last fiscal year.
For us. So the balance is actually 290,024
Yes, sir. That's correct.
in the recovery fund.
That's correct.
Okay.
Yes, sir.
That's just because I know when we got on Capitol Hill, that's one of the things they were looking at was how much was everybody sitting on. And of course, we're not like the realtors, but just wanted to make sure where we were on that. So we're supposed to be at a minimum of 250. We got 40 extra. Am I understanding that correctly?
That's correct for the recovery
All right.
fund. And then, of course, you have the overall operating budget, that first page. So that's the two difference.
All right. So if we get into publishing newsletters, does that come out of that money?
Yes, sir. That's correct.
All right. That's what I want to understand.
Yep. The newsletter and the seminars are your education recovery fund.
Sometimes we don't ask questions because we don't want to sound stupid, but I'm trying to understand.
Oh, I'm glad. We welcome questions. I tell folks around that work for us, questions are stress tests. Those are good.
Right. We don't need to make any motions on this.
We'll go to the next line item then, which is basically the trends, the page number 3. And this is just a snapshot of each month. You saw the overall picture, so now let's take a look at this one. Basically, we're looking at overall health of the licensing revenue coming in. Looks pretty good. We're looking at 20,000 last or September, and then expenses of about 13,000 give us a net surplus of 6,000 or right under 7,000. But we're tracking for the year an overall revenue of 51, right under 52,000, and then we're looking at expense about 45. So we're tracking in the positive of our net surplus of 6,600, 68.
So again, for clarification, the historical trend, these numbers is licensing and case revenue. You got the fiscal year 18, 17, 16 below it. Is that for that month? For those years?
That's correct. That's correct. And that way we can match it for the prior fiscal years, which, is really helpful to us. So if we can see if we're getting off the rails. And that's actually why we were able to discover the fact that we had money coming out of the education recovery, or excuse me, out of the general operating budget that should have been coming out of the education recovery fund.
Answer me this. So if we have licensing revenue that says 14,270 for fiscal year 18 for that month,
yes, sir.
That does not tie up to any of those numbers above it.
That's correct. That's correct. That's a separate. That was fiscal year 2018.
Fiscal year 19.
Yeah, that's right. We're in
starting in
fiscal
July 19.
That's right.
July
that's
of 18. So fiscal year 19, we had licensing revenue of 17,500.
That's correct. Yes, sir.
Compared to a 14,270 in 18.
That's correct.
Okay.
And you saw we had the years prior to that, 19 and 21.
Tracking. So for the year, let's see, we had 15, 30, 45, $47,000 versus 52,000. So we're above where we were three months in 2018 versus 19.
Talking about September.
That's the licensing revenue, or is that bottom line? Total revenue says total revenue 16,690, right?
Yes, sir.
And so that was for 2018. That was 14,270.
Yes, that's correct. That was that's your total. What's your
that's your total
that's
revenue.
Right. That's right. That's correct. Your and then right below that would be your expenditures. That's correct.
And then expenditures below.
Same
that.
model.
Right. Okay. All right. Our expenditures are tracking about the same.
That's correct.
All right.
Yep.
So we're a little above on revenue and about the same on expenditures.
That's correct.
for the fiscal year.
That's
3 months
correct.
in.
Yeah, we're doing good. Yeah, we're tracking right where
All
we
right,
need to be on
all
that.
right.
That's correct.
All right, just make sure us.
Yeah, no, that's good. Okay. Any more questions on the budget? Okay. If we can, then that was all for informational purposes. We really don't have anything else going on, and as far as the budget to report. But so we'll move on, if it's okay with you, Chairman, to the newsletter. Okay. You have two options there on based on your feedback that was provided. So we'll need to vote on which one of those you prefer. There are three things that are missing on that newsletter. One is the calendar dates. We're going to talk about that today. We'll vote on those dates today, and then we'll add that. There's a couple places for standard disclaimers that we'll have to add there as well. Commerce and insurance type disclaimers, and then also we'll probably we'll beef up the disciplinary report. So we'll probably add the disciplinary report from the last couple meetings, so that's a little bit more exhaustive as well, instead of just a single item there. But other than that, that would be your report.
It's going to be a paper letter that's mailed out.
Yes, sir, that's correct.
So what happened to the online letter?
We were talking about the IT upgrades or enhancements for renewal notices as well, but they can send. They ask for the email addresses, so they can send that to their email. So that's not a problem. But you mean putting it on the website like a link?
Like other states, and I thought that's why we were in the situation we're in now, is we wanted to, like North Carolina, Kentucky, about all of them, instead of mailing out the paper, but you just get it online.
We're looking at a couple options. Obviously, they're gonna mail it out as well, but we can create a link and just put it on there as well. That's not a problem.
So what is this one going to cost?
I haven't seen the numbers, but it was somewhere 15,000, 16,000 something. It was under 20. For
3 or 4 publications a year?
That's right, for the total contract.
So we're right back where we started when the in-house wanted to do it themselves, right?
When you talk about in-house wanting to do themselves, you're talking about expense.
The lady, Nicole, she was really pushy to do away with this and put it online, or let her do it here and mail it out. And that's why we're in the situation we're in now, and, I think it's totally uncalled for.
Well, Nicole, when she left, I think when she first came here, the idea was that we had the staff to do that, and she hired somebody for that purpose. Neither one of those folks are here any longer. And with the budget, the Education Recovery Fund, it just seemed to make sense at that point to hire a vendor to do that and put that out for bid. So that's where we're at. That's the history. You're right. That was the arrangement initially, but this is where we're at now.
How many bids did you get on doing this?
I think I want to say that was the only one. I don't recall anybody else bidding against Nashville Auction School, but I mean, I can't say for sure, but I don't recall there being another one other than this one.
So we're going back to paper, and it's going to be mailed out.
Yes, sir, but we can also do a link. That's not a problem. Questions in regard to that or comments?
I want to comment, if you had to pick one or two, I like option one better than option two myself. That's just my personal opinion.
Comments as regard to the options or discussion in regards to that?
What was the consensus of who sent information back on the 1 and 2?
There's a couple folks that responded to me, and both those folks and Mr. Morris was included in that, said option 1.
Yeah, both of them look good. The only thing I added was to beef up the disciplinary report, but either one of them's fine. Do you need a vote on that?
Yes, Chairman.
Anybody wants to look at them.
I'm proud to know it's going to go back to paper, so maybe everybody start talking to us again.
I do have a question. You may have answered it earlier in the discussion, but can that also be? I'm in favor of it going out in the mail. So when I ask this question, it's not a loaded question. Can it also be emailed?
It can.
Okay.
Yes, sir.
Okay.
Mm-hmm.
I was going to make a motion to put it back in the mail.
Yeah.
So it make everybody happy. But
Yeah.
Just go ahead.
I'm in favor of both.
Any way we can get it to them, that's best. Reinforcement of 3. So if you can get paper, email, link, let's do it.
How long has it been since you all have received them in the mail?
A couple of years.
2 years.
Yes, ain't.
2 years.
We've
I think
been
it'd
waiting
been too
2
long.
years to get straightened out. Go to the rescue.
Motion to do that.
Motion we accept version number 1.
Second.
Commissioner Lewis moves that we accept option 1 in the newsletter. Commissioner Morris seconds that. Any further discussion? All in favor say aye.
Aye.
Any opposed? No. Option 1 it is. CE update. Audit update.
Yes, we've been looking at. We talked about a 5% audit for each quarter. Yeah, and we proved that, I believe, either last meeting or the meeting before that. So just want to give you an update where we're at on that. We done our first audit not with auctioneers yet, but with court reporters, and so we've worked out the bugs with them. They were first in line, and so we've already got an IT request through. We've already mapped out what we're supposed to do, and so I imagine in the next couple weeks or so we'll do our auctioneer audit. So then I'll report if there's any hiccups or anything going on with that, but. The short of the long is if folks don't comply with their CE as requested within, I think I believe it's, I want to say 30 days, I believe. If they don't comply within that period, then they'll end up on the disciplinary action report is how that'll work. But and then you'll know about that from that medium. As far as the Nashville Auction School goes as well. Apparently that things went well at their last meeting. You have their evaluations from their students there. They had 44 in attendance. They had their first seminar this fiscal year in East Tennessee, and their next offering will be in Middle Tennessee at Columbia State Community College. And of course, our website on the announcements page, first page, will update all that information for them as well.
Anything else on the audit?
No, sir, that's it.
All right, moving on to the 2019 meeting dates.
All right. If you take a look at those, it should be on your iPad there, and then let me know if we basically just mirrored it from this year. So if that looks fine, we'll move forward. But if there's any discussion, of course, we can entertain that as well.
That's a third Monday every month.
I believe so. Yes, sir. Every quarter, third Monday.
Right.
Yeah.
Is my term? It's up in 19, right?
I haven't looked at it, but you're, of course, until you get the thank you for your service letter from the governor, you're welcome to serve, and we would encourage that.
If it's 19, I'm done in August.
I'll look for
I was
it.
giving you warning.
Yeah, I'll look at it then.
Anybody got any problems with the dates?
No, I'll tell you, I like the quarterly meetings. I think we get enough done meeting that often, and I move that we adopt those dates as presented.
Morris makes a motion we adopt these dates. Second.
Second.
Second by Mr. Collier. Any further discussion? All in favor say aye.
Aye.
Any opposed, no.
Right.
Task force update.
I wanted to put this on the agenda because I wanted, since y'all asked me to represent the commission on the task force, and there's, I think, 13 members on the task force, and I was going to kind of let you guys know what our thinking is. We have hopefully our last meeting next Monday. We made a presentation to the task force about 2 or 3 weeks ago, and want to kind of bring you up to speed on what we're presenting. I want to get your feedback. There's not anything that we need to make a motion on or anything, but this is just for informational purposes only. But since I'm representing the commission, I felt compelled to at least tell you what our thinking was and get feedback to whether you liked it or not, because I wanted it to be representative of the entire commission and not just my opinion. Part of the task force duties was to try to figure out a way to provide an ease of entry into the business and into getting an auction license. We've been criticized because of the onerous rules that we have for getting an auction license and keeping an auction license, and we're trying to be more competitive within the marketplace as far as other states are concerned and make it a little bit easier for guys to get into the business and to accomplish the goals that their professional aims are. So what we came up with was basically kind of an overhaul of the auction law and creating, instead of just either an auctioneer or an affiliate auctioneer, there's actually going to be 3 classes of auctioneers. And there would be an A class, a B class, and a C class. The C class would be for those guys that only want to be a bid caller. They don't want to be in the business. They don't want to do anything other than have a license to be able to go out and conduct auctions for other people. And they would basically get a Class C license. Now, this licensure for that bid caller would basically have a kind of a basic core education package about the auction law, contracts, UCC, ethics, professionalism, and personal insurance. Bid calling instruction would be completely optional. A lot of those guys grow up in the business and already know how to call bids, and they learn to call bids on the job, that sort of thing. And they would this would allow reciprocal auctioneer license from other states, so long as they had proof of a basic core. There would not be an apprenticeship for that program. You would just go be a bid caller. And that would be your Class C license. So you wouldn't have any continuing education. Once you had it, and you would, like I said, you wouldn't have an apprenticeship for that role at all. And so that would be your Class C, and it would be a new class of auctioneers on that. Now, those guys would not be able to negotiate or enter into an auction contract. They would not be authorized to take possession of any seller assets. They would not be authorized to take possession of any auction proceeds. And they would only be able to put themselves out of being able to conduct an auction. Okay? So other than that, that's all they would be able to do. Class B, which would be for a business track or a business auctioneer, that would be the equivalent of what our auctioneer is today. And so those guys would have a higher level of entry. They would have a higher level of educational requirements. They would have a basic core plus 34 hours, and they'd have to have asset-specific instruction. They'd have auction processes, advertising, promotion, technology, live auctions, auction math, escrow accounting, sales taxes, business basics, bankruptcy, estates, personal property and assets. There would be a testing process, and you would be subject to having to be an affiliate auctioneer or what we call an apprentice auctioneer prior to getting a business track license. You would have CE, but that holder of that license would basically be responsible for everything within that business, for all affiliate auctioneers, for any complaints, for any monies handled, for any contracts issued, for any assets taken in possession, any escrow monies taken in possession. They would be singularly responsible for all of those things. So we're going to try to hold those guys as being the responsible party for any and all activities within that business. Now, this would basically eliminate the need for a gallery license, and we would not have any more gallery license or non-auctioneer firm licenses, so that we would have an auctioneer that we can point to and people can't hide behind just having a gallery license. The A class would be the same as the B, but they have the additional requirements of the public automobile auction law. They would be our auto auctioneers, and they would have even a higher level of educational requirements pertaining to motor vehicle law, titles, insurance, liability, the auction process, sales taxes and escrow, and sort of. And they would be the only ones that conduct a valid auction of public automobiles. So that would be our Class A auctioneer. Now, we're still going to have exemptions to the Class A auctioneer, which would be a bona fide business liquidation, business fleet reductions, selling repossessed vehicles, or selling vehicles in estates with a rule of 5 vehicles for that estate, which is still the exemption that we have now. Now, we've pretty much, on the task force, agreed to all the above that I've just mentioned. Where we're still trying to come up with is this issue about defining a time listing, which is what started all of this, and that's for online auctions. And I think we're going to try to hold our feet to the fire on that, in that we do want to have a definition of what a time listing is, and that if we have any advance of time past the deadline for that auction, it becomes a live auction at that point and become under the purview of this commission. So we would have that by statute, and we would have the ability to fine and oversee those people that did that. The other things that we talked about doing was allowing all education to be either online or in the classroom, because we want to catch up with the 21st century, that education is now online and available, and allow more people to do more education on a more freely basis. It would eliminate the gallery license, and we talked about this, and I'm not sure I'm fully in agreement with this, but they talked about getting away from the recovery fund altogether and just switching to a $20,000 surety bond for all licensees for 2 reasons. One, they can any claim against the recovery fund is limited to $10,000 per case anyway, and it can only be for two actions. And we haven't really had anybody to be able to penetrate that recovery fund and actually get anything. They have to go through a lot of hoops, whereas we had a surety bond, they could act against that surety bond a lot quicker and a lot more directly without having to go through commerce and insurance to try to recover their money from the recovery fund. So I'm open to discussion about that, how the feelings of the commission are of that. It seems to make sense, but like I said, I'm not sure if that's the best way or not. I know there's pluses and minuses. But that's, in a nutshell, what we're talking about doing with the auction law, and I'm anxious to hear any feedback from the other commission members.
Saying the apprentice auctioneer will be called affiliate, is that to line it up?
Yeah, they're going to try it. Yeah.
Oh,
The other thing that they talked about doing, and this was in discussion purposes, was eliminating the 2-year wait period on affiliate auctioneers, and there was a discussion about eliminating the point system. I said, no, I think we ought to have the point system, but if they get all their points done, only have a minimum wait time of 6 months, which allows somebody who's on a fast track and understands all of there's some companies that are very active, and there are some companies that do one every once in a while. And so for those young affiliate auctioneers that are learning the business while having another full-time job, it may take them a lot longer to get all their points in to get everything done versus a guy that goes to work for an auction company and is engaged in that business each and every day. So we're talking about, once you got your points, that the minimum wait time would be 6 months. And then we were talking about changing it from apprentice auctioneer to affiliate auctioneer, just to be more in line with what an affiliate license is in the realty program. This is just a terminology thing that they were talking about doing.
Would the time of the license for the affiliate be 2 years? I mean, would they be a 2-year for the license, and then they could upgrade within the 6 months? Right. They can
upgrade after 6 months. And there's an unlimited number of affiliates that any auctioneer may have under him versus just having the 2.
Said the A's would be like automobile auction.
A's for automobile.
So you're still going to have to carry the automobile auctioneer license.
That's right.
Okay.
Right. Yeah, it's another level of education over and above the normal auctioneer.
Not going to be a gallery.
It's not going to be a gallery at all. again, we're looking for a responsible party that this commission can hold responsible for any and all actions under that business.
So if I open a gallery, I would either have to hire you or I would have to be the auctioneer, right?
Yeah, you would have to have an auctioneer conduct that auction, and only the auctioneer could enter into the contracts to sell the goods in that auction.
So that's basically the way it is now, right?
Except now the gallery owner can take those goods in and sign the contract,
Okay.
but he's not responsible for selling those items. But this would make that person become an auctioneer, and you don't have to call bids, but you'd have to have that license to enter into that contract and to operate that escrow account for that business.
And the firm license would go away as well.
Firm license would go away as well. That's correct. So we don't have to have one license versus two licenses. Or if you're in the real estate business.
Five, because you got to have a real estate firm.
Yeah.
Man, I got you.
Any other comments or questions or anything? And just, do y'all kind of like it or not like it?
I'd like it.
Okay.
I agree with
Adam, what's your, as a public member?
I like the fact that it's streamlined.
Yeah. Okay.
I hope we can get something nailed down on the online.
Yeah, well, that's the primary, and we've got one member that's really pushing hard back against that, but again, I kind of got up against him and called for the question, and we voted it, and he voted against it, so.
So did you say that there's nothing that you guys can address about the tag sales?
You know, that doesn't come under the purview of this task force, and that would be up to the legislature to be able to address that directly.
I didn't know whether you might could send something to them, or
I wish.
I do too. Yep.
I say thank you for your service on that. That's you guys have been busy.
Thank you.
We appreciate that.
We send our best.
Yeah, better you than me. All right, anything else there? Ready for the legal? Yes. Go ahead.
Good morning. My name is Keith McCarthy. I serve as the disciplinary counsel for the commission. Today we have 11 cases. All cases have a 10-digit case number. I will simply be referring to the final 5 digits of each case throughout today's proceedings. The 5-digit prefix is always 2018-0. So for example, our first case, 2018-0, I will refer to it simply as case 41371. I'll proceed by summarizing this complaint. This case is an administrative complaint opened in June. It is against a licensed real estate broker. Now, the law is specific when it comes to auctioneering for real estate brokers. From the facts of this case, it does not appear that there is a violation. Specifically, that is because the law requires that a licensed real estate broker vocally conduct an auction to be in violation of unlicensed activity. In addition, it is not a violation of the advertising requirements either. If you could turn to the second page of the report, I've included the exact advertisement that caused so much question. Although this ad may not be wise, although it may not be a standard form in the state of Tennessee, it does not violate Tennessee auctioneering regulations. This licensed real estate broker disclosed an ad for highest and best offer. She even included words for an opening bid price. At the end of the day, there was no back and forth with an audience. The licensed real estate broker simply received offers for the property. If the commission has any questions, I would encourage the commission to discuss.
I will say this has all the appearance of being a sealed bid auction. We do sealed bid auctions, and a lot of the same language is put in there where you say, you know, submit your highest and best, and we're going to open all the bids. And, you know, we don't ever put any there about it being a reserve, but, the seller has the right to approve the high bid. If it doesn't meet, the seller has the right to reject any and all bids. All that sort of thing. This is really borderline. Even though they didn't ask for any advances back and forth as far as moving the bids up, be careful when you see things like this. I caution you that this has all the smell of being a sealed bid auction. And auctioneers use that a lot in real estate, especially for land and that sort of thing. But I'll go along with your recommendation to dismiss that if they do this much, it's really a sealed bid auction. Even though they don't ask for any advances, they're asking for the highest and best offer, open them all up at the same time, have the right to reject any and all, has a reserve amount. It's still that comes under the purview of being an auction. So that's my comment.
Better? No warning or?
Yeah, I think we can.
Sir, that would be appropriate. And in the context of this case, there's a specific exception that's at play, and there is a Tennessee Attorney General opinion. And because it's a specific carve-out for licensed real estate brokers, that is why I make the recommendation that I make. Were this not a licensed real estate broker, the outcome certainly could be different. But a letter of warning would certainly be appropriate.
Yeah, I'll move that we send them a letter of warning and to bring their attention to what the law is. But I would agree with that we dismiss with a letter of warning.
Motion's been made to dismiss and send a letter of warning to the individual. Is there a second?
Second.
Second by Commissioner Lowe. Any further discussion? All in favor say aye.
Aye.
Any opposed, no.
Chairman, if I may, we dismiss the complaint if there is some form of discipline. So for this one, it would just need to be a letter.
Okay. Is that okay with you?
That's fine with me.
All right.
I'll amend that motion.
Will you amend your second, Commissioner Lowe?
Yes.
All right. Note that. All right. Ready for number 2.
Second case, 43501, is about unlicensed activity. The complaint was filed for a consumer, and this matter was investigated. In this case, the respondent admits to calling bids and conducting regular auctions. The respondent holds open to the public an auction barn. Each month there are several auctions. Right now there is no evidence as to whether or not respondent possesses sales tax receipts. A second investigation was requested in this matter. Counsel recommends dismissal on these grounds. If someone is auctioning off their personal property, that is also a specific exemption under the auctioneering law. And as of right now, there is insufficient investigation to show whether or not all the property being auctioned for the past several months at this auction barn was the personal property of respondent.
So, give you a little history here. A lot of people try to use this exemption, and what they'll do is they'll buy everything from all the consigners for $1, quote unquote. Now it's their property, and then they sell it off, and they split the proceeds with the consigner. So that's one thing we got to watch for. They're trying to skirt the law by taking possession as being theirs, and we see that a lot in certain parts of the state. And so next time it gets investigated, they might investigate a little bit deeper about, well, where did it really come from? They're trying to use this, well, it's my property, I can sell it if I want to, exemption so that they don't have to do it. So that's just my only comment. I would agree with you to dismiss based on what the facts are so far.
Is there a sign up, or are they advertising this as an auction, or how are they getting their crowd there to buy it?
Yes, sir. There is a sign on the building. There are numerous Facebook advertisements.
I'm not an investigator, but I mean, if an investigator goes to the auction, it's pretty simple. You just mingle with the crowd, say, hey, I'm interested. You guys know how I do that. Just gather information I mean, they'll tell you exactly what you need. It'd be pretty easy to figure out, in my opinion, but I would agree. So, all right.
I made the motion.
Second.
Motion's been made to dismiss. Second by Commissioner Lewis. Any further discussion? All in favor say aye. Aye. Any opposed, no. Passes. Number 3.
The next case involves two related case numbers ending in 46551 and 46531. Both are unlicensed. This administrative complaint was opened in June. An investigator was sent to determine if respondent was auctioning property without a license. And as the auction dates approached, a licensed auctioneer was indeed hired, and the licensed auctioneer provided a sworn statement to the investigator, and the respondents both corrected their advertisements. Because there is currently insufficient evidence to show respondents violated Tennessee Code 6219-102A, counsel recommends that this administrative complaint be dismissed.
Make motion to accept counsel's advice.
Second.
Motion's been made by Commissioner Collier, second by Commissioner Lewis, to dismiss. Any further discussion on this? All in favor say aye. Any opposed, no. It's dismissed. Number 4.
Case ending in 43681. This is a case against a licensed auctioneer, and I will be asking the Commission to discuss and consider a monetary fine against the licensee. The complaint was received in July, alleging bid rigging at an absolute auction. The property was owned by two brothers and their wives. The licensed auctioneer advertised an absolute auction. That is crystal clear. What is also crystal clear are Tennessee statutes. Tennessee statutes state that a seller is prohibited from bidding on his own property at an absolute auction. At the auction, when the property got up to $535, there were only two bidders left. One was one of the sellers. And that seller signed a contract with the licensed auctioneer as a seller. Numerous documents state that the individual was the seller. Granted, there were 4 sellers. He still signed as a seller in numerous locations. In addition, the licensed auctioneer accepted a bid registration card for that seller. That seller even received a bid number. Once the property got up to $535,000, only the complainant dentist and the seller were left. Bids went back and forth all the way up to $800,000, at which point the dentist, not the seller, purchased the property. This case was also referred to the Sullivan County District Attorney's Office, and the Sullivan County District Attorney's Office requested that our Attorney General's office investigate this matter. Pending your questions.
We've seen this type of activity in partnerships where you have the same. Let's assume that the brothers weren't brothers, but they were partners in the business, and where partners are trying to dissolve a partnership, and they'll put it up for absolute auction. The partners will bid, and the public will bid, and I'd feel a lot better about this case if one of the brothers had actually been one of the bidders and then closed on the property and paid the other siblings from the proceeds. Then that would have made it a little bit easier to dismiss, because in that case, when you're dissolving a partnership, whether it be family or not family, you are allowed in an absolute auction to bid in those cases. The fact that somebody else, a third party, was actually the high bidder and they were running the bid from the brother makes it a little bit more difficult, because we don't know what the intent of the brother was. If he was the high bidder, if he been the high bidder, would he have closed on that property and paid his other brother and wife their share of the property. Without knowing the intent, it's hard to say whether they were just running the bid or actually bidding, and that's the problem in this case, for me.
I agree with Jeff because you don't know, and it's basically is dissolving a partnership between the two brothers because they own the farm. You know, one may want to buy the other one out, and a lot of times that's the most fairest way of doing it. It's put it up for bids, and high bidder gets it, and it may went above what he wanted to pay. Who knows? And I'm with Jeff on this.
I agree. I mean, we don't know the intent of. I mean, if they deeded it to the brothers beforehand, and then they're just selling it to settle the estate, even if it was in their name. But
What was their response to the complaint?
The licensee responded, sir, and the licensee's response was that that brother, that seller, intended to buy the property. And there's no other evidence, yay or nay, on that issue.
It's going to be hard for me to find him not knowing. I mean, it's went above what he was willing to give to pay his brother off. The way I look at it, I'm not for finding him. I make a motion to not put the fine on him.
Dismiss?
To dismiss.
I'm going to second that.
any further discussion? We have a motion on the floor and second. All in favor say aye.
Aye.
Any opposed, no. Dismissed. Number 5.
This next case, ending in numbers 61251, is against a firm. It is allegations of selling unlicensed activity for sale of automobiles. This case was investigated both from the motor vehicle standpoint and as well as the auctioneering standpoint. Investigation had gone back and forth into this matter. In addition, the respondent in case 61251, the licensed firm owner, submitted a response admitting the sale of one vehicle at the automobile auction. Initially, there was supposed to be 4 days of auction, and the auction was to occur on the private property of the seller. The evidence shows that the licensed firm owner was told that the seller had a car lot in the state of Tennessee. Investigation shows that no one in this transaction had a license to sell motor vehicles. Respondent's actions appear to be in violation of 6219-102, which states in part, it is unlawful for anyone to act or advertise or represent to be a public automobile auctioneer unless the person is duly licensed as a public automobile auctioneer and as a motor vehicle dealer. Counsel recommends a letter of warning regarding unlicensed activity, the violation of the aforementioned statute. And if the commission would like counsel to read the letter from the respondent.
Yeah, I'd like to hear it.
Respondent states, Attorney McCarthy, I spoke with you by phone concerning this complaint against my auction company. As I said, we sold one car for a total of $700. No other automobiles were sold. The seller who I was conducting the sale for led me to believe that he had an auto dealer's license, stating that he had a car lot in Tennessee. I did not receive any compensation at all for the sale that was scheduled for September 7th, 8th, 14th, and 15th. The seller canceled the sale on September 8th, about 1 hour into the sale. I depended on making enough money at this auction to catch up on house payments. I only owed 5 years on the home. However, due to not receiving any compensation and being on disability myself, I have now lost my home. I have no intention of getting into the auto selling business. I am 60 years old and not in good health. The respondent goes on to state that he earns disability and that he more than likely will retire his license in 2020. And respondent also submitted this to the investigator. Pending your questions.
I think your letter of warning is an appropriate response, so I would move that we do what you suggest.
Motion's been made to concur with counsel and dismiss. Second by Commissioner Lewis. Any further discussion? All in favor say aye. Aye. Any opposed, no. Dismiss. Number 6.
Mr. Chairman, I have a question. Is it a dismissal or a letter of warning?
Oh, my apologies. Letter of warning.
Thank you, Ann.
Thank you.
Thank you. She is done. She is.
He's just
on
seeing
it.
if you was listening or not.
Thank you.
Now the sixth case, ending in 62221. This is against a licensed auctioneer. It was an anonymous complaint stating that there was an absolute auction for real estate subject to court approval. Now the adding question was submitted along with the complaint. The facts are fairly straightforward. 4 sisters agreed to sell a home that they inherited. The licensed auctioneer advertised it as an absolute auction. Under the law in Tennessee, an absolute auction cannot, by definition, be subject to court approval. As the Commission is aware, an absolute auction is most likely to draw the greatest interest, the highest bids, the best crowd. Respondent, with the assistance of counsel, submitted a response to the complaint. Respondent states that because one of the sisters may not have been able to sign the deed of sale, that he wrote, pursuant to the advice of counsel for the seller, again, not his own attorney, but counsel for the seller, that he would put subject to court approval on the advertisement. And this was because he was not sure if the final sister could sign at the actual closing. There's no other evidence on this matter. Fourth sister recovered from her illness and was able to sign the deed, and the property did not sell at the absolute auction. Respondent states it's still up to the attorney to decide if the estate sale needs court approval. Advertising requirements in the state of Tennessee are clear. False, deceptive, misleading, and untruthful advertising is expressly prohibited. In addition, advertisements cannot contain a misrepresentation of fact, and it cannot be misleading or deceptive. Finally, an auctioneer, auction firm, or gallery shall not permit its name or license number to appear on any advertisement not in compliance with Tennessee law. Under the letter of the law, this advertisement was clearly not in compliance. It appears that's what the complainant observed, and the complainant requested that this matter be reviewed by the Commission. Counsel recommends a $500 civil penalty for violation of Tennessee law.
What's going to be important in this case is the timing of when the auctioneer found out from the attorney that they wanted to change the terms and conditions of the sale. If he found out if he knew that prior to advertising, then yes, he would be in violation. If he didn't know this or wasn't told by the seller's legal counsel to add that language until the day of the sale, then I don't know how we hold the auctioneer responsible if he didn't know. So the timing of him knowing is going to be really critical to whether we make this a fine or not. I have seen cases where, and this happens to auctioneers, where there's sometimes a smarter legal counsel for the seller than there is auctioneers, where they advertise an absolute auction and then the seller's attorney shows up on the day of the sale and says, well, we're going to convert this from an absolute auction to a reserve auction, even though they spent weeks advertising an absolute auction in order to gather that crowd that you discussed. It's perfectly within the seller's rights to make that change, but if there's collusion with the auctioneer to have that happen on auction day, then now you've got a problem. But if the auctioneer is unknowingly a part of that transaction and the seller makes that change, or if the seller's attorney in this case comes up and says, well, we got to have court approval because of this sister, then I can't hold the auctioneer responsible for that. But so that's where we would need to know, at what point did the auctioneer know that this was going to happen?
The auctioneer states in his response that at the time of advertisement, he specifically included that language for that reason, and counsel would contend that because he was privy to that information, he should not have advertised an absolute auction.
Now you're exactly right, because you can't have it both ways. It's either an absolute auction or it's not. There's not. It's like trying to get semi-pregnant. You can't. So it's just one of those things. So if he knew it, then yes, he's in violation, and he should not have advertised it as an absolute auction, knowing that provision for the subject to court approval was going to be in play. So I would concur with your recommendation, and I would make that in the form of a motion to fine the guy $500.
Second.
Motion's been made and seconded to concur with council issue a $500 civil penalty. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. It passes. Number 7.
Case ending in number 69361. This is a complaint against a licensed auctioneer. The complainant alleges that he made 2 high bids on a tractor via the internet. The tractor ended up selling for $25,250. The complainant bid that amount and $22,500. The respondent submitted portions of audio from the auction and also submitted a statement in response to the complaint. The complainant provided screenshots that show that his bid is crossed out twice. In addition, there is an individual that is an online controller, and complainant contends that the controller notified the auctioneer that there is a higher bid. In addition, respondent licensee's voice is heard asking for the same price complainant allegedly bid 2 times. Respondent's voice then can be heard saying sold. The next audio that is audible is the controller stating, I have $25,500. Respondent then says, sorry, I just sold it. Complainant states, I wanted, at a minimum, to make the board aware of this negative reflection of auctioneer corruption on the state of Tennessee. Counsel has requested that this matter be investigated. Counsel also recommends that the Commission find a violation of 62-19-112B12. And this is conduct of an auctioneer that demonstrates, in this case, at least at a minimum, incompetent dealings. Respondent should have checked more diligently to see whether or not online bidders had a high bid in place. Complainant's bid during the auction, due to complainant's bids during the auction, counsel recommends a civil penalty of $500 and that the Commission discuss this matter.
Said it sold for $22.50. Is that right?
Yes, sir. $250 less than
Did the
complainant's second
auctioneer
bid.
say sold?
The auctioneer said sold for the lesser amount. Yes, sir.
Did you hear it?
Yes, sir.
You heard him say sold for $22.50.
Yes, sir.
And it was the guy that's complaining's bid.
No, the respondent.
Well, I'm just trying to understand.
Yes.
Was the company doing the online bidding, were they on site or were they doing it through phone, or how were they communicating to the auctioneer the bids?
We don't have those facts. What we do have is that there is a controller a female controller that is the go-between between the online bidders and the auctioneer. And her voice is rather clear for portions, telling the licensee that she had the higher price after he said sold. Before he says sold, you can hear a female's voice. It's not clear what she is saying.
Is that the online platform's recording of it, or is that the auctioneer's recording of the sale?
We received it from the auctioneer. That's all we know, sir.
A lot of those companies, they work like in a motel room, and then you're out on site, and a lot of times that's delayed, and that can be a mess right there.
Yeah, there can be a.
I don't know.
There's a lot that can go wrong there, and then it not be the auctioneer's fault.
I do some sales with internet, and it's a lot of times you sell it, and then they'll start hollering they got this or got that, and if it's delayed or some of the phone systems don't work good with it, and so
when you're taking a live bid on the ground, and then they're having to input that into a computer, and then someone's having to type back in to respond to that, and then they're going to have to relay back to the. There could be 6, 8, 10 seconds there worth of time between happening live on the ground and on the internet, so that's tough to say. If a lady was standing right there on site with him and was able to communicate with him, to me would be a little bigger. It would hold more ground than if they were at a remote location and just trying to get the word back to the auctioneer. For me, it'd be hard to. I would want to know that information before I made a judgment on this.
I concur. We do these live simulcast auctions a lot, and when we're doing them, we have to literally make ourselves pause at the end when we're saying prior to selling sold, but sometimes an auctioneer, just in the normal routine of what his normal calling pattern is, he'll say sold before he really probably intends to. I don't know of an auctioneer ever that wants to sell short, and I wouldn't think. I wouldn't want to fine him. I would want to dismiss the case, or maybe not dismiss it, but maybe fine him guilty, but only issue a letter of warning to say, you need to maybe pay attention to this or have a better system in place. I wouldn't want to send him a civil penalty for this. It can happen, and I've had people complain to me that said, well, I was trying to put it in, it wouldn't let me put the number in, and I know that it will, because all I got to do is push the button one time. Some people just don't understand technology and how to make it work for them. So again, like these guys said, there's a whole lot of slip that can happen in these kind of deals, and so my recommendation is send a letter of warning to maybe be aware of these systems and to have a little bit better timing on waiting for that last bid to come in versus the civil penalty.
I'll second that.
Motion's been made and seconded to issue a letter of warning to the individual. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. Passes. Number 8.
Case ending in number 71181. This is a complaint against a gallery. The complainant alleges that a child is serving as an auctioneer each month, and that a child is calling out bids as well as homosexual slurs to bidders. The complaint specifically says that the licensed auctioneer and the licensed apprentice are allowing this kid to be an auctioneer. Complainant also alleges that an illegal raffle is being held each month, where the licensed apprentice's wife calls out a bidder's number at each auction. If the bidder has left the auction, the raffle increases in dollar value. When the jackpot gets high, as in $100 and above, the licensee's wife calls out a bidder number for whoever has spent the most money at the auction. Complainant alleges that others have also noticed this activity and that no one can see the number that the wife pulls. Complainant concludes by stating, one should not have to pay to qualify for the giveaway. The licensed apprentice for the gallery has submitted a response to this complaint. There's no other response in receipt at this time. The response states from September to December, we have Christmas funds for children in need for 3 counties that wouldn't have much of a Christmas otherwise. The response goes on to state that a donor's son, aged 15, called a portion of the auction for the donated goods, wherein all proceeds go to the Christmas fund. An investigator, the complaint included pictures. Individuals were all in short sleeves. There was no signage for any type of fundraiser or charitable event going on. The child was in shorts, calling out what appeared to be bids from the podium with the microphone. The licensed apprentice denies that the child used any inappropriate language or name calling of any kind. The licensed apprentice's response regarding the allegedly illegal raffle states, "This is money that we freely give away, and I use the app Randomized. This is an app that randomly picks a number. Those numbers consist of every registered bidder." Again, the complainant submitted photos, and there are no signs or notices about a Christmas fund nor any charitable function depicted in any of the photos. Accordingly, counsel recommends a civil penalty of $500 for violation of Tennessee Code 62-19-102B12 for improper dealings and/or incompetent dealings for permitting a minor to serve as an auctioneer.
Tough one, ain't it?
What was the child selling?
Counsel's not aware what the child was selling.
Allegedly items donated for a special Christmas offering or something to...
Yes, that's what the facts show, and that's what the only facts we have at this point are.
But the investigation shows different, right?
All we have is the complaint at this point, which included photos.
Did the respondent submit a response other than the app that they used?
So specifically, this case number is against the gallery, and the response came back from the apprentice. So we don't have a response from the owner of the gallery. We don't have a response from the licensed auctioneer. It's the apprentice that submitted the response.
There was a licensed auctioneer at the sale?
That is what the facts show at this point, other than the time where the 15-year-old was calling bids.
I think what he's asking is not just the apprentice was there, but the apprentice's sponsoring auctioneer. Both were there along with the child that was there.
I don't have those facts, sir. Either way.
We don't know for sure that the sponsoring auctioneer, the apprentice, was there either. Sure, we have enough information on this one to...
I agree with you.
Sounds like the lady's just mad she didn't win the money, but it does sound like.
We don't oversee the raffle act.
I guess I would like to hear something from the gallery as well as the sponsoring auctioneer, some sort of response or some...
So this complaint was filed when? In this summer?
One moment, sir.
Okay.
Complaint was made in July, and he's saying from September to December they have a Christmas fund. That's kind of a... Sounds like if they do this from September to December, it was from the following year. She's waited 6 months to.
The complaint was received October 8th, and the evidence shows that it is an auction that occurred in September, and yet the apprentice is arguing that it was for a fundraiser trying to get the charitable exemption, it may appear, for this Christmas fund. But at the end of the day, all the facts show that a 15-year-old is being allowed to host an auction. That evidence we do have.
On charity auctions, you don't have to have an auction license to do a charity auction. That's where the gray line is. If that child was selling items other than for charity, then yes, you're right. But we don't know what he was selling. We don't know what the proceeds from what he was selling were going for, or how they were presented to the crowd, or whether the auctioneer was even present at the sale, and whether he was overseeing that, or whether the gallery owner was there, not the auctioneer. So I don't know if we can get more information from a response from them or not. I don't know what's your feel from that.
The commission should then have this matter investigated. If the commission's...
Why don't we do that? I would like to have some additional facts on this case, maybe represent in our February meeting, if you don't mind.
I agree. Did you make that into a motion?
I will. That's so moved.
Second.
Motion's been made and probably second to defer this to our February meeting for more investigation. All in favor say aye.
Aye.
Any opposed, no. Pass. Number 9.
Cases 9, 10, and 11 are all related. I will begin with the representation of case ending in 41311, which will be referred to as Respondent 1, and that is an apprentice. Case 41821 is Respondent 2, and that is the gallery. At the last meeting, the Commission requested that a complaint be opened against the licensed auctioneer in this matter. So that is a new case. That has case number 61811, and that will be referred to as Respondent 3, who is the licensed auctioneer. Now, if you turn to page 10, I will go over the facts again from the last meeting. This is a complaint that was very well written by a consumer alleging that Respondent 1, the apprentice, held himself out as an auctioneer and not as an apprentice. The complainant did not receive payment or did not receive the return of no less than 145 items. On April 26th, Respondent 1 represented himself as an auctioneer and claimed to have been in the business for over 30 years. She came to the complainant's home to look at her antiques. He also provided an estimate of the values and discussed auctioning off the antiques. At this initial meeting, the commission that would be charged was 25%. But later, when the licensed apprentice shows up with a moving van and movers, the price on the contract goes to 40%. The complainant had asked the apprentice for market value, and the apprentice provided receipts for approximately 40 to 44 items, but not the full number of items. The complainant had thoroughly researched current values, and she contends that she was not in any rush to sell the items. The apprentice stated he could sell the property for current value and even perhaps get a little bit more. It was clear that complainant did not want to give away the antiques. The auction was set for Friday, July 7th. And on July 3rd, the complainant dropped off remaining items and provided the respondent with another list of the items. Respondent 1 stated that a check of the proceeds would be mailed to the complainant. At no time did any paper documentation or any verbal discussion disclose that Respondent 1 was only an apprentice. On the consignment form, Respondent 1 signed as an auctioneer. Now, after the last meeting, it is clear that the third respondent in this matter, the auctioneer, is also the sponsor, the signed, notarized sponsor on the appropriate Tennessee form for the apprentice. Go a little bit out of order right now and read you the response we received from Respondent 3. Again, the Respondent 3 is the licensed auctioneer. His response: please retract the statement that a complaint has been filed against me. The complaint is question is on Respondents 1 and 2, not Respondent 3. I, Respondent 3, was the contract auctioneer the night the merchandise was sold. The items were offered to the general public at auction with no reserve and brought the value the public deemed. The remainder of the entire complaint revolves around the contract and negotiation between Respondent 1, the apprentice, and the complainant, of which I have no purview or jurisdiction. So that is the response we received from the auctioneer. At the end of the day, complainant alleges she provided the Respondent 1, the apprentice, with 189 items. She received a check. The check was not for all of the items. Some items were returned damaged, and many of the items were never returned, and the vast majority of the items never had a receipt or any type of documentation attached thereto. Counsel has reviewed the matter, and it appears that all advertising provided by the complainant was done online under Respondent 2's name, the licensed gallery. The gallery is owned and operated by the apprentice. So this gets into the issue of the galleries that we opened the meeting up with. Respondent 1 is an apprentice. He also owns a licensed auction gallery. The main issue with regards to this complaint is that the consignment contract does not state whether the complainant is dealing with the apprentice in his capacity as an apprentice, or if he's representing his sponsor auctioneer. Since Respondent 1 signed as the auctioneer, that could be misleading. Pending questions from the Commission?
All right, so let me get this straight. This apprentice auctioneer has a gallery license. So he's operating his own business as an apprentice auctioneer under Respondent 3's license.
Under his own, sir.
Well, I know, but he's an affiliate. He's an apprentice auctioneer. He has to be sponsored by an auctioneer who is Respondent 3, correct?
The law requires that.
Right.
We don't see that occurring.
Okay.
There appears to be no supervision in the response from the licensed
you're getting to my question. But Respondent 1 and Respondent 2 are in and of the same, but one's a gallery and one is the apprentice auctioneer. So he's taking this stuff in, and he signed the contract with the lady, made the quote, made the estimate, did all of the work. Respondent 3 is claiming he wasn't involved other than being the sponsored auctioneer.
He does not claim that. He claims that he is only the contract auctioneer for that one-night auction in question.
So did he call the bids?
He called the bids, yes, sir.
Okay. All right. So now, did the lady get her stuff back or money for the stuff that she sold or not?
For 145 items, she has not received the money. Documentation.
To this day, she has not gotten paid.
As far as we're aware, yes, sir.
Okay. That's a problem. So I would want to find the apprentice auctioneer, the gallery, and the auctioneer in this case on all three for those things. And that's my personal feeling, because whether he likes it or not, whether he was involved or not, and whether he just called the bids or not, again, that's why we're wanting to have this responsible party. The auctioneer is responsible, whether he Now, if he lets the guy run loose, that's his own problem. He has to suffer the consequences. So he will be fined in this case, if it's up to me.
Council recommends that the commission authorize a consent order as shown on the final page of the legal report. For Respondent 1, the apprentice, offer him the opportunity to pay a civil penalty in the amount of $1,000 for violations of 6219-112B3, 62-19-112B9, and 6219-112B12. In addition to the regulations .21, .12.7, and .12.9a. For Respondent 2, the gallery, Council recommends the Commission authorize a consent order offering the gallery to pay a civil penalty in the amount of $1,000 for violation of 6219-112B12. Finally, for Respondent 3, the auctioneer, Council recommends the Commission authorize a consent order offering Respondent 3 to pay a civil penalty in the amount of $1,000 for violations of Tennessee Code 6219-112B12 and 62-19-112B9. In addition, the violations would include the regulations set forth under .20.5 and .12.4, 6, and 7.
Well, I concur with council, and I'll make that in the form of a motion that we do that. And I look forward to them coming before this commission if they would like to challenge that consent order and have a formal hearing.
Motion's been made. Is there a second?
Second.
Second by Commissioner Lowe. Any further discussion?
I would, before we vote, if I'm reading this correctly, and this would probably be a change for the minutes, but the recommendations list Respondent 1 to pay civil penalty for each of those. So that would be corrected, okay. Ready to vote?
Any further discussion? All in favor say aye.
Aye.
Any opposed, no. Pass. Is that it?
Chairman, we're in new business, I believe. Are we done with the legal report then? Looks like we wrapped it up. We're in new business. Unless there's anything as far as in that regard, we discussed earlier on about the potential of election of officers. We were going to wait till February to do that. Of course, we can do that now if folks want to do that as well. That's fine. But I can let you know just right now our chairman obviously is Commissioner Thorpe, and then our vice chair is Mr. Collier. And Mr. Collier, we did look, and your term is up in August the 31st, 2020. So you would be eligible if you like, because you were reappointed recently, and so that do that term got you to 20. What's that?
When was that? When did that take place?
I don't have the reappointment paperwork in front of me, but if there's any variation in that, I'll let you know. And
Got reappointed last year. You got 3 years, Coach.
I didn't get reappointed last year.
Just recently. I don't know the date, but I remember seeing some reappointment.
Ain't nobody told me nothing.
Okay. Well, I'll follow up that
So 16, they did it for 16, I think, around 17 or 18 before I got notified. 19 is supposed to be my last. It's going to be my last. August of 19.
You got 2 more years.
Me and you gonna get back.
You got 2 more years, right?
No, I ain't either. If you look, I come in 13.
Yeah, I know.
And I got reappointed in 16, but I didn't get notified till about end of 17.
8/31/20. Mr. Ronnie Collier said,
Yeah,
black and white, right?
Yeah,
here.
it's fine.
Wendell made a misprint.
I'll pull your reappointment paperwork and we'll get that to you.
It's 19.
Mine is up.
John, you.
Because I don't have a clue. I think that's for chairman.
I think
I
John
that's
is
for-
20.
I think,
I
they
think
put
your
that
I
on
think
some-
yours is 20.
John
Yeah.
is 20. Mine is 19.
You just
Mine is going to
you
be
just been
19.
1 year, haven't you?
Yeah.
John's
No,
is
no, it'll be
20.
2 in January.
If you like, we'll just look at everybody's.
Thank
and
you.
Yeah, I
we'll
think
get
we
that
need to
straight.
look at it.
And then February, we'll be prepared to do election officers then, okay? All right, sounds good. That was it.
Any other new business?
I make the motion to adjourn.
Motion's been made to adjourn, second. All in favor, say aye.
There you go.
Thank you, gentlemen.
Glad we got that straightened out.
Not.
Going nowhere.
I got to
John's doing such a great job as chairman. I think it was.